We got breaking news in the E. Jean Carroll case, two-barreled. One, Judge Kaplan has ruled in her favor and has ordered the clerk of the court to disperse more than $5,700,000 that she's owed from having beaten Donald Trump by proving that he sex abused her, defamed her, and the jury awarded punitive damages on top of it. That $5,779,783 has been sitting, running with interest as a cash bond posted by Trump. That has to do with one of two cases that E. Jean Carroll, the sex abuse survivor,
obtained off of Donald Trump. The second one was for $83.5 million, and that one is still kicking around at the United States Supreme Court. But because about a week and a half ago, the United States Supreme Court, without opposition, not even the mega Supreme Court justices, ruled in Donald Trump's favor to block the payment of the judgment or to grant the appeal. In fact, they dismissed a petition without objection, without dissent, and based on that and a prior order by Judge Lewis Kaplan, that it's time for Trump to pay up.
Ordering that the clerk disperse the money. I have that copy. Moments after that, Donald Trump, using Alina Habba's old law firm, yeah, it still exists apparently, run now by Michael Medallo, filed their notice of appeal arguing, but Judge, we have a petition for rehearing with the United States Supreme Court.
Rehearing with the United States Supreme Court. Again, a U.S. Supreme Court that ruled 90 against him. After considering the petition 13 times during conferences, they finally dismiss the appeal and he thinks, but I have a petition for rehearing. They just decided against you 90. You're not going to win that petition for rehearing, and that shouldn't delay anything. The Judge Kaplan, knowing about the petition for rehearing, said that's not one of the grounds. Final and conclusive ruling, and a petition being denied is enough.
And that is
that new ruling. That's the top line of the ruling. I'll dive in deeper here on the Midas Touch Network and Legal AF. Let's get down to it. Jean Carroll, formerly of Elle magazine, was an acquaintance of Donald Trump in 1996. She proved to a jury of her peers 90, federal court in New York a couple of years ago, that she was sexually assaulted and abused by Donald Trump in a dressing room in a department store called Bergdorf Goodman's, the women's department store diagonally across from Trump Tower. She bumped into Donald Trump at the revolving door, made some playful banter. By the end of that afternoon, she was pushed up in a dressing room, and she was sexually abused. Beyond that, other witnesses testified in that first trial about them being sexually abused by Donald Trump in and around the same time, including Natasha Stoof, who worked for People magazine, who said she was sexually attacked by Donald Trump while she was there doing a puff piece about his new marriage to Melania Trump at Mar-a-Lago. And we also had Miss Letters, who testified that she was upgraded to first class, sat next to a guy she didn't know but learned was Donald Trump, and he sexually abused her as well. That, along with the Access Hollywood tape in which Donald Trump claimed that he could grab a woman by her genitalia and get away with it, all went into the jury. A number of appeals happened about the defamation that happened after Donald Trump was no longer president, when he attacked E. Jean Carroll and said, "Oh, well, she's not my type." Okay, and he didn't testify in the first trial. Jury returns a verdict, $5 million. Trump has to put up a cash bond out of his pocket to bond out, or he'd have to pay it immediately while he pursued his appeal. The appeal bounced around to the Second Circuit. There were arguments made about all sorts of evidence that they didn't like that Judge Kaplan let in. It was eventually rejected by the Second Circuit Court of Appeals, and then he filed his petition at the United States Supreme Court when he became President of the United States. Again, 13 times the U.S. Supreme Court considered that petition. They couldn't get 4 votes to pull up that petition as a real appeal in any of the 13 conferences. And finally they found 5 votes without dissent. Not even Clarence Thomas, not even Alito to support him. Not even the 2 guys on the United States Supreme Court who have been accused of sexual abuse or assault or harassment in their own lifetimes, like Clarence Thomas and Kavanaugh. Not even they voted for Donald Trump. So Donald Trump's magical thinking that his new petition for reconsideration is going to result in him not having to pay the money is exactly what I just said it is. It's believing in the Easter Bunny and golden unicorns in your backyard. Here's what the judge just ruled.
Order directing disbursement of deposited funds from the registry of the court. Whereas on May 11, 2023, the court entered a judgment against Donald J. Trump in the total amount of $5 million in favor of plaintiff E. Jean Carroll. Whereas on June 23rd, 2023, the court entered a stipulation and order regarding a cash deposit, and the defendant, Trump, made a cash deposit in the registry in the sum of $5,550,000 that had kind of interest baked in pursuant to that order. Whereas the stipulation and order provided that the clerk shall deduct from the income any fee that she's allowed to collect, whereas the stipulation and order provided that after the latest of a mandate issued by the Second Circuit in connection with an appeal, a denial of a timely filed petition for writ of cert to the Supreme Court, if any, or upon the Supreme Court's granting of cert and an order in favor of the plaintiff may collect any monies owed by defendant.